A very cheerful morning to our honorable speaker, Ashwini Pawar ma'am, all faculty members and students present here. I welcome you all for the Impact Lecture Series. Today we have with us Miss Ashwini Pawar ma'am. She is registered patent attorney of the Patent Office of the Government of India. She pursued her master's degree in biotechnology from Pandit Ravi Shankar Shukla University in year 2012. And then she worked in the life sciences industry for a year. After that, ma'am has pursued her career in intellectual property laws as a patent attorney. She has been working in the field of intellectual property for more than 6 years. So without wasting time, now I request Pawar ma'am to enlighten us with her thoughts. Over to you, Ashwini ma'am.
Good morning, everyone. Um as ma'am has said in her introduction, I've done my MSc Biotechnology in the year 2012. And after that, I've been working in first in patent searching and then as a patent agent. So currently, I'm working at Am Legal Associates, which is located in Pune. So, for today's session, the topic I will be presenting is uh, awareness of IPR and specifically patent life cycle. So, why patent life cycle? Because we being from technical background, we will as a, being from technical background, we will if any IP is suitable to us, so mostly it would be patents, because there are other IP forms which are suitable for different purposes, which we'll see in the following slides. Yeah. So first of all, we will see what are the various types of IPR. So the various, as you can see, the various type of IPR are patents, trade secrets, copyrights, and trademarks. So one by one, we'll understand which IP is suitable for what kind of invention or technology. So patents is basically for any technical invention, like it may be your product or it may be your process or any device. So that comes under patent. And next is trade secret. So trade secret is something, basically trade secret is that it's not known to the public. It's somewhere kept hidden, like what we generally refer as secret. So only that the secret pertains to some inside matters of companies or any trade. Like for a very common example of trade secret is like recipes for any kind of food or beverage. So the formula of Coca-Cola is a very classic example of trade secret. So next is copyright. So copyright is something that is used to protect literary works, some art forms. For example, songs or some artwork, all those things, or like your novels, any writings, those things are protected under copyright. And next is trademark. So what usually comes under trademarks are logos, symbols, some taglines associated with marketing. So such things come under trademark. So in today's presentation, we will be learning more about patents. So first of all, we have to understand what exactly is a patent. So patent is a right. It's your it's an intangible property where you are protecting your technical invention. But before going for patent, first we have to understand that not everything can be patented. There are some conditions which we need to fulfill for getting a patent. So those conditions are known as, here we are calling it as patentability criteria. So for any invention to be patented, these conditions need to be satisfied: novelty, inventive step, and checking non-patentability under section 3 and 4, and its industrial applicability. So what exactly is novelty? Novelty means that your invention should be new. It should not be known anywhere. Whatever is present already in the domain, it should be different from that. That is known as novelty. So next criteria is inventive step. So what is inventive step? So basically, in layman terms, if we talk about inventive step, you can see it like a jigsaw puzzle. Like when you join 2 to 3 pieces of jigsaw puzzle and the puzzle gets completed. So in that terms, when we see inventive step means that your invention should be not obvious. It should not be obvious that, yeah, like I'm taking technology 1 and technology 2, or I'm taking some teachings from one reference and the other reference. I'm combining the teachings of both the references, and then I'm arriving at an invention. So that won't be considered as patentable. So it should be non-obvious, that it should not like, yeah, let's me combine these two, yeah, ho gaya. No, you can't do that. There should be actual, you should have some good feature and some inventive feature which will make your product or process stand apart from the processes or products already known. So that is inventive step. Next is we have to check, like in our Indian patent law, there's a section 3. Under section 3, the patent law has listed various points that such inventions would not be patentable. For example, anything that is related to traditional knowledge. So like here many people must be knowing that someone in US had tried to patent turmeric for its healing properties. But as we all know that in our country, people have been using turmeric in households for healing purposes from very long time. So such things are non-patentable as per our Indian law. So anything that is related to traditional knowledge, or anything that like you're changing some form of the substance, like once it is known as powder form, but same product you're making in liquid form. So that such products are not patentable. And next is industrial applicability. So whatever your invention is, it should have some practical importance. It should have some commercial value. That is when it will get patented. So these are the criteria for patentability. Now we will be moving on to the patent life cycle. So when I say life cycle of patent application, what we mean here is starting from the filing of patent application till the patent getting granted, and things that need to be done after the grant of a patent. Those all things we will be covering in the life cycle of patent application, and this is specific to our Indian patent law, Indian Patent Office. So as you can see here, phase 0 is invention, phase 1 is filing patent application, phase 2 is examination, phase 3 is hearing and grant, and phase 4 is post grant. So we will see all the phases one by one. So phase 0, what is phase 0 and what do we mean that what needs to be done at an invention level. So suppose you're doing some research in your lab and you come across an idea. When you come across an idea, that's the start. But you should know that ideas don't get patent. You need to have a proper technical disclosure for getting a patent. So once you get an idea, that would be conceiving the invention. So what would be the next step? Even before you start researching extensively, you have to make, and especially if you are targeting to file a patent, you have to make sure that uh, whatever idea you have conceived, is it already known? Has anyone already secured a patent for that kind of technology? Because if they have already secured a patent, and if you keep on working, like you're working for 1 year, 2 year, and then you will go to file a patent, and then you come to know, no, this has already been patent, so your work will become useless. So that's why it's very ideal to conduct a prior art search before filing a patent application. The first step that is always recommended is a prior art search. So what exactly is a prior art search? So prior art search, we are looking for, suppose there's a technical domain, or you have a patent idea, or you have a technical disclosure or invention. So that invention, is it already known? Are there any patents related to it? Are there any literature or research papers or any such product? Is there any product in the market similar to what you're trying to patent? All these things are done in prior art search. All this searching is done in prior art search. So once a prior art search, so what are the other advantages? One is that you will be looking like if is your patent actually new, is your invention actually new, or is it already known in the art? Here we say art, whatever is known prior. So is it already known? So suppose in your prior art search, it is if we observe that this is already known, so then what can we do? You need not panic. You can just improvise your invention. You can improvise your invention. You can modify it substantially. Or even sometimes prior art searches are also done to identify a white space. White space as in like a specific area of a domain where there still there's a scope for research. Not much research has been done in that area. Such research area is termed as white space. So you can conduct prior art search to identify the white space as well. So when you identify white space, the chances are less that your invention might clash with others. So you can work in such research areas. And suppose the invention is already known, then you can make substantial improvements and then go for filing of a patent. So after a prior art search is conducted, the next step would be drafting of patent application. So for drafting of patent application, you have to like there's a particular format for any given patent application. It's not cannot just write up simply submit a write up and ask for a patent. There's a given structure of a patent application. You have to always adhere to that structure and include your technical details in that format, and then uh, it can be submitted to the patent office. So in the following slides, I will show what is a typical structure of a patent application, especially Indian patent application. And next is prototype. So suppose if you have any device or some kind of any other product or formulation. So after patent drafting, you can work on that, or you can fine tune your device. So sometimes it happens that patent examiners ask for such prototypes during hearing. So it's always a good idea to keep a prototype ready. And pilot study is the actual implementation of your invention on a small scale to study or to understand the actual working of that invention and how it works on a bigger scale, and to show that it has practical utility. So this I have summed up. Moving on to the next phase. So in phase 0, so phase 0 is basically searching for what is known and to establish that your invention is new, and if it is not, then it is recommended to work on it and to make it better than what is already known. So, and in phase 1 comes drafting of patent application. So it's not a compulsion that a patent application needs to be drafted by an agent itself. Anyone can draft. Only thing is, whatever rules are set by the patent office, those rules need to be followed. And then after drafting, the next step is filing of patent application. So patent application can be filed online as well and offline also. Only thing is offline, for filing offline, the fees is a little bit on the higher side, and for online the fees is a little bit less. And in case you want to file offline, then you have to go to the patent offices that are located in few cities. Like in our region, the patent office is located in Mumbai. The other patent offices are located at Delhi, Kolkata, and Chennai. These are the prominent patent offices. So this is about filing, and for filing, s- there are some government fees, and these government fees vary as per the filing person. Who is the what filing person is better known as applicant. So based on the type of applicant, the fees vary. So suppose the applicant is a large entity. So for large entity, there are higher fees. And if it is a natural process, any individual is filing, then those fees are less. And now recently, educational institutions have been considered as they have been considered for lesser amount of fees. So fees for educational institution and individual is same as per the latest rules. So it's like incentivizing the educational institutes to file more patents. So once you file a patent application, what happens next? So once you file a patent application with, like suppose if you have filed a patent application today, the patent application, before that, I would like to mention that a patent application can be filed. There are like two filings. You can either file a provisional or you can file a complete specification. So like suppose you have an invention, but you need to do some work on it, some experimental studies or something, and you need some time. So it's always a good idea to file a provisional specification to secure the date. So once you file a provisional specification, then you can file a complete specification within 12 months. So you secure the date, but also you get additional 12 months to finalize your patent application by filing a provisional specification. And if your work is complete, you can directly go for complete specification filing as well. So once a complete specification is filed, so whichever your first filing date, it is also called as application date. So from your application date, after 18 months, the patent application is published in the patent journal issued by the patent office. And suppose you don't want to wait for 18 months, you can always file for request for early publication. So when you file for request for early publication, then the patent office publishes the patent within 2 months. And after that, actually after that it comes request for examination. So from your filing date, within 48 months you need to file request for examination. And if you don't file your request for examination, then your patent application gets lapsed. So when you what do you mean by request for examination? So when you're filing for request for examination, you are asking the patent office to examine your patent application. it's like you're seeking their approval. So that is request for examination. So now the question remains is, what is PCT entry international patent? I'll just go back. Yeah. So sometimes what happens is people are in talks with investors, or they have a specific idea of a market that they want to market their invention or product in US, or they think that their product has a good demand in China. So we need to understand that a patent right is territorial. So it is restricted in terms of geography. So suppose you are filing a patent application in India, it will be considered as protected. Your invention will be protected only in India. So suppose you want to protect your invention in US or China, you should file a patent application in those countries as well. So as you know, there are a lot of countries. Sometimes it might happen that you want to market your product in 10 countries. So it is a very tedious process to file the patent application in each and every country. So there is a provision called PCT application. So PCT application, so like whenever your Indian complete specification is ready, at that time, uh, you can go for PCT application. Actually, the timeline for filing a PCT application is 12 months from the filing date. So suppose if you have filed a provisional, then PCT entry can be done within 12 months of filing a provisional. And suppose if you have filed a direct complete specification, still it will be 12 months. So whatever your first filing is, from that date, it is 12 months. And what is exactly PCT? So PCT means Patent Cooperation Treaty. So under this, you will file one patent application. And after filing that patent application, you have 30 to 31 months time to determine which countries you want to actually file your invention. So this protects your date, and it gives you time to actually think whether you want to enter other countries or not. It's always a good idea to file a PCT application, especially if you are looking to monetize your inventions outside India. So moving on to phase 2 of the patent life cycle. So as we had discussed in earlier slide, that we will be filing a request for examination. So once we file a request for examination, the Indian Patent Office issues a first examination report. So what is this first examination report? So in first examination report, the controller or the officials at the patent office will see whether the invention you have filed, does it comply all the requirements that are required to file a patent, like especially the patentability criteria we had seen in the first slide: novelty, inventive step, industrial applicability, and to check whether is it actual patentable or it falls under non-patentable subject matter. So all these things they check, and they check whether your patent specification has been drafted properly or not. Does the drafting, is it as specified in the patent law, or there are some deviations? So if there is any, or there is any irregularity in following procedures, or maybe some file form has been missed, we forgot to file some form, all those things are checked by the patent office. And if anything is remaining, or if there's any fault, all those are given in the first examination report. So as an applicant or inventor, it is expected from us that we are supposed to reply this first examination report within 6 months from the date the report was issued. So within this 6 months, you have to give your response. So that is known as response to FER under section 24(1) rule 24B, to put the application in order of grant. So suppose your response to FER. So what exactly is response to FER? So what happens is in first examination report, some citations will be given. They might be patent citations or they might be literatures like research papers or something. These citations will be given, and such citations are given that are closely similar to your invention or patent application. So in response, it is expected that we have to give the differences. So you have to tell them how your invention or patent application is different from the cited references in the first examination report. And along with that, if there are any changes that are recommended by the patent office, like some amendments in claims or something, those things also need to be done. And every objection given in the first examination report will have to be complied. And the usual time period to giving a response to FER is 6 months, but this can be extended by 2 months by filing Form 4. So sometimes it happens that for some reason we missed filing, but you have to file it within the due date. Like you cannot file extension after passing the due date. Well within the due date, you have to file for extension. Like suppose like 15 days are remaining for your response or something, but you think you might not be able to finish it on time, or you have some emergency, you can file for an extension and get an additional time period of 2 months. So that is done under section 21, rule 24b. So all these sections and rules that are written here are given in the Indian Patent Act. So this was phase 2 of the Indian patent life cycle. So now moving on to phase 3. So what happens after we file a FER response? So if the controller is satisfied with our reply and they think we have complied to all the objections, many a times patent application gets granted after FER response itself. But suppose they think, no, still this issue is there, still this objection is maintained or retained, they are not okay with our response. In that case, a hearing notice is issued. So what in here hearing is actually, it can be both, either you can go for physical hearing at patent office before the controller, or you can do video conferencing also. And usually applicants and patent attorney both can attend the hearing. And suppose if the applicant doesn't want to attend, only the patent agent can also attend the hearing. Or suppose if anyone is filing without a patent agent and they have done it on their own, they themselves can also attend hearing. So that's not much of an issue. So in hearing notice, you get a chance to interact with the controller one-on-one, and sometimes it happens that it is very difficult to explain in a written format. So here you get a chance to explain them one-on-one. So if you actually think, no, these are the citations, but I think these are some features that make my invention stand out. So you can do it in this one-on-one discussion with the controller. So after appearing in the hearing, you have to again give a written submission. This written submission is similar to the response to FER. As you had drafted response to FER, in the same way you are supposed to prepare a post-hearing submission document. And again, if your some formalities are remaining, some forms are misplaced or like wrongly filed, you can rectify that and submit it. Usually controllers give specific instructions on what is the problem that is there in the drafting, or this form was not filed, or this form has this discrepancy. The discrepancies are usually specified, and you have to accordingly rectify that and file it again along with the post hearing submission document you have prepared. So post hearing submission is again your defense that you will be giving, be it regarding novelty inventive step or non-patentability. Suppose they are saying invention is non-patentable for so and so reason. So, but if you actually think, no, my invention is actually patentable because it has these features. So all that data you have to give in the post-hearing submission. So after submission of this document, the patent is either granted or rejected. So once this decision is taken, you can see this on the patent office website. And also whatever email ID you would have provided, you will get a communication on your email ID as well. Even if it is granted also, or even in case if it is rejected also, you will get a communication. So once this decision is finalized, this decision is also again reflected in the journal. So our journal is updated on every Friday, weekly once. So every Friday, whatever new publications are done, so like that publication after 18 months, those publications are also visible on Friday, and even the grant of patent, that is also published in the journal. So this happens on every Friday, weekly. So opposition, post-grant opposition. So before discussing post-grant opposition, I would like to say that opposition can be either pre-grant or it can be post-grant. So when we say pre-grant opposition, then pre-grant opposition can be filed by anyone before the grant of patent, no matter at what stage it is, whether response to FER is being filed, or whether a hearing is done, or whether post-hearing submission is submitted. As long as the patent is not granted, you can file a pre-grant opposition. Similarly, there's a post-grant opposition as well. So when can this post-grant opposition be done? So usually since from the grant date, that is if the patent has been granted today, so 1 year from today, within this 1 year, any interested person can file a post-grant opposition. So here we have to understand that pre-grant opposition can be filed by anyone, but post-grant opposition is strictly to be filed by person interested. It's like, suppose you're an inventor who is working in some one specific field. Say you're working in making of keyboards or something, and that patent is related to some additional feature in keyboard. So you can file post-grant opposition. But any other layman person, suppose there's a chartered accountant, he actually has no such technical interest as such, but just because someone told him or something, or just for the sake of it, if he files a post-grant opposition, that won't be considered. You need to have some genuine interest. It should somehow affect you. Only then you can file a post-grant opposition. And this timeline is fixed. Suppose the 1 year has been crossed, then you cannot file a post-grant opposition. So regardless of post-grant opposition, you have to renew your patent application. So first we have to understand that the life of a patent is 20 years. So whatever right you're claiming, your patent, so that is valid for 20 years from filing date, from the application date. So whatever date you have applied for a patent, from that day to 20 years, you have to, that is the life of the patent. But to keep it alive, you have to file fees for every year. So these fees is different for different years. So suppose if you don't pay the fees for, like, you have paid till this year, but next year you miss to pay the fees, then that patent will be lapsed. It won't be active. And suppose if someone has like used your patent, you won't be able to take any legal action because your patent has been lapsed. So if you want to protect your right, you have to renew your patent application every year. So along with renewal, there's another activity that you have to do each year. That is, you have to provide the statement of working. So what exactly is statement of working? So statement of working is a document that will be like suppose your patent invention has been commercialized and it has generated some revenue, or you have licensed your patent application to some third parties and they have generated some revenue. All these details you need to provide it in statement of working, and this statement of working also you have to submit every year for the entire term of the patent. So now we will briefly see about the PCT. So this was about till now we have seen the patent life cycle of Indian patent. So along with this, for an inventor, it is important to understand the PCT process as well, because this allows you to protect your invention across the world. So this is a brief timeline of the PCT. So as we had stated earlier, we have to file a PCT application within 12 months from date of filing or priority date. So here you can see at 0 month, like this will be a filing date, file local application. Then after that, within 12 months, you have to file PCT application. Then at 16th month, an international search report is issued. This international search report is same or equivalent as the first examination report issued by the Indian Patent Office. So they will basically be commenting on the novelty and non-obviousness of the invention, whether those criteria are fulfilled or not. This happens at 16th month timeline, and then at the end of 18 months, the PCT application is published. So once the PCT application is published, there's a website called Patent Scope by WIPO. On that website, your PCT application will be visible. And then after initially an international search report is issued, but in some cases we can also request for supplemental international search, that you can again request to the authorities to issue another search report. So that supplemental search report is issued at, you can request it at 22nd month, and it will be published by 28th. So it is known as International Preliminary Report on Patentability. So and at 31 months, national phase entry happens. So what exactly is national phase? So once you file a PCT application, so PCT application is something you file with WIPO, and then now you want to enter specific countries. So some countries you can enter within 30 months, and some countries you can enter within 31 months. So for like US, you have to enter at the end of 30 months. So now you want to enter US at the end of this 30th month. Before this or within this timeline, you have to file a patent application in the US Patent Office. But the date you will get is this date when you have filed the local application. That is the purpose of PCT. You might be filing it after 30 months from your initial filing, but your protection will start from this date. So this is the main advantage of filing a PCT application. Or otherwise, if you want to file a US application, then you will be supposed to do all this process during this stage only. So you don't get the time to analyze, or sometimes people want to do research whether what markets would be suitable. Like you have a product, but you don't know where exactly it has market. So you need to identify market as well. For this, you require time. So filing a PCT application uh, allows you to have this time. It gives you a time of almost 30 months to decide whether you want to go in a specific country or not. Or suppose if you require funds, this 30-month timeline gives you time to arrange for funds as well. So after once it enters a national phase, that patent application will go through all the steps like we had discussed for Indian Patent Office. It will be examined by the, like suppose if you're filing in US, it will be examined by the US Patent Office. and then they will issue a report, and then we will file a response, and then they will decide whether it can be granted or not. So this was about PCT. Yeah. So phase 4 is basically what we will be doing after the grant of patent. Basically, you can consider this as a maintenance of the patent application. So for the first year, you will be have to keep a watch if any post grant opposition has been done against a patent or not. And on a regular basis, you need to file statement of working for each and every year. Then suppose, like especially for educational institutes, it happens that they come up with technology, but manufacturing capabilities are not there, or they don't want to invest in manufacturing capabilities. So in that cases, a patent is usually licensed out to someone having manufacturing capabilities. So you can always license out your patents, not necessary that if you have a patent that you yourself need to commercialize it. That's not required. You can just make an invention and license it out to third parties. And then after that, maintaining patent. When we say maintaining patent, we mean that you should renew your patent for every year, and for that you need to pay the fees accordingly, whatever is specified by the patent office. Vigilance and enforcement. So you have to keep an eye if someone is using your invention or not. If suppose someone is using, so we need to make sure that our patent is not misused. So if they are using our invention, technically they should be providing some royalties to us, or especially they should have consent from us. So if not, that's wrong. So there, then you'll have to send them a notice or ask them to stop manufacturing or selling the product. So those things come under vigilance and enforcement. So till now, whatever we discussed was about the patent life cycle. What are the various steps that we have to go through to get a patent granted? So right now, what we are seeing is what is the typical structure of an Indian patent application. So as you can see, these are the fields. If at all anyone considers drafting a patent application, we have to make sure that the invention or the subject matter is disclosed under these heads. So the invention is supposed to have a title. You have to give a field of invention wherein you will be specifying to which technical domain your invention relates to. Then background of invention. In background of invention, it is expected that you have to discuss what are the issues with existing technology and how your invention is a solution to those problems. That or the general history of the technical domain to which your invention belongs. So that you need to discuss in background of invention. Then you have to give a brief description of drawings. So as per our Indian patent law, drawings are required to be submitted in a different document. You cannot submit the textual matter and drawings within one specification. Textual matter is supposed to be given in form 2, and drawings are to be submitted separately. So since drawings are submitted separately, you have to give a brief description of drawings, like the title of the drawing, what exactly is given, like figure 1 discloses so and so. So that is known as brief description of drawings. Then comes the description of invention. In this description of invention, you can give all the technical features of your invention. And then comes examples. So in example, suppose if you have any experimental data, or you have done some studies, or you want to give a working example. Suppose if you have a device and you want to describe how it works. So all that you should give in examples. And then come claims and abstract. So here I would like to point out that claims is the most important part of of a patent application, irrespective whether Indian or not. Claims is what is the scope of the protection of your invention. Whatever feature of your invention that you want to protect, that is supposed to be disclosed in claims. And then abstract is a brief summary of your invention in like 100 to 150 words. So here actually one of the field is missing. There's also summary of invention. So after background of invention, you have to give summary of invention. In summary of invention, you have to discuss your entire patent application in a concise way. So just give me 1 minute. I would like to show you what exactly claims look like. So can anyone confirm if my screen is visible?
No, madam, your screen is not. Now it is visible.
Yeah. So this is what a typical patent specification looks like. This is the first page. Here you have your inventor details and then your patent application. This is the field of invention, background of invention, summary of invention. So brief description of drawings, detailed description of invention. Here you suppose if it is a process, you can mention all the steps of the process, all the parameters of the process, what temperature you are using, what pressure you are using, or what chemical reagents you're using, all those things. And in examples, mostly we give experimental data. So after examples is the claim section. So this is a typical way of writing a claim. And here you suppose if you are having a process, then you have to give a detailed. So in claims also there are dependent claims and independent claims. Your first claim is always the principal claim. So you can describe whatever your product or process is. You make sure to explain all your features in that claim, and then whatever other parameters are there, those you can disclose in the dependent claims. So this was a typical what claims look like. So you have to make sure to include as much as details possible in this claims. So summing up, I think so this was the structure of Indian patent application. So before filing any patent application, it is always good to have a fair idea of the entire patent life cycle. And so accordingly, we can plan our actions and prioritize what we want to do, how we want to do, and how we are going to proceed. So having an idea of the patent life cycle helps you to manage your resources in a better way. So anyone has any queries?
Students, you are free to ask questions.
So you can
We
ask
expect free
anything.
Hello.
questions from your side.
Good afternoon, ma'am. This is Ashit. Ma'am,
Good
actually,
afternoon.
we are working on a startup idea and
Hmm.
we have coded our own website. So, ma'am,
Hmm.
my question is, as you told the structure of Indian patent application,
Hmm.
ma'am, as that same structure follows for copyright process also?
No, copyright is an entirely different thing. This was strictly for patent.
Madam, can you show them some application for copyright if
Copyright.
possible? The way you
Actually, ma'am,
showed
my forte is limited
patent.
to patents.
Patent. Okay.
Okay, okay, ma'am. Thank you so much, ma'am. Yeah.
Yeah.
So, madam, like while giving your presentation, like you told, I think what I gathered, I am going to say, like
Hmm.
when a patent is awarded to you all,
Hmm.
after that also you have to keep it active by
Yes.
submitting few reports every
Uh,
year and paying some
yeah,
patent
that
fee.
it's just
Yeah.
a form, ma'am, statement of working. You have to give nominal information, and apart from that, you have to keep renewing the patent application.
Acha, acha. How much is normally? It is how much of
So,
this?
ma'am, actually, based on the applicant type, the fees are different. But for
Okay.
individual and even throughout the term of the patent, the fees are different, and it keeps changing for every 4 years. So after every 4 years, the fees go to the higher side. So like
Okay.
initially, it is for first 4 years, it is 800 per year.
Mm-hmm.
Then it is a little bit higher. So like that, it keeps on increasing.
Acha, acha.
Yes.
Okay. One more thing, for copyright also, is it the same? Any idea you have, ma'am? Like you have to, once you get a copyright or so, you have to do.
No, ma'am. For copyright, I have no idea.
Acha, you're okay. Uh, Anyone else? Any other question? Madam, if it's possible, like, can you give some few encouraging, like, most of our audience right now is students. So, from their perspective, like what they should do so that they can apply for patents, how should they go about it?
So,
Can
like, ma'am,
you
as we had,
highlight that particular
yeah.
point?
So as we had discussed in phase 0, ma'am. So like, suppose if anyone, um, like comes up with an idea, or you have a concept, you think it is new or novel, or yeah, this looks interesting to me, or basically um, you you should not develop something just for the sake of it, or just making similar to what already exists. You should have some add-ons in it. You must be some solving, at least even if it is a small problem, you have to solve some kind of small problem. Like maybe there's one search engine or something, but then your search engine gives some additional advantage, like either it gives like good results, or it has some kind of unique algorithm which gives you unique output. So there should be some enhancements in that. Instead of making same to same whatever is already known, you have to bring about some enhancements. That should be, first of all, for getting a patent, you have to develop your mindset that way, that whenever you're working, we have to make sure that we are bringing on something extra to the plate. So like even when we are doing any research, it is expected that you are addressing some problem of that technical domain. Similarly, for patent also, you have to if you are developing a product, you have to make sure that your product has some additional features. It should not just be additional, but it should be some useful feature. It might, you can make, suppose there's a very tedious invention or something, like tedious product which requires lot of manpower or something. You can develop something simple which can be uh, made by operated by a single person. You are solving the problem of manpower. Similarly, like there's a process for, like you have a process for, say, making a special kind, not a special but a regular kind of paper, but you have developed a process in such a way that you reduce the time required for making that paper, or you are getting more amount of paper. So that is what unique you're doing in your process. So even such incremental values also constitute an invention. So it's not necessary that your product or process should be entirely new, because we are living in an era where many inventions have already happened. But even if you are bringing about some incremental value in the existing inventions, so that is also accountable for getting an patent. So you have to think that way, and also keep reading. So suppose if you have an interest in a specific research area or something, keep yourself updated, keep reading the latest papers, or even try to sometimes even explore patents also. Like whatever you can find on Google. You can always make a habit to, especially if you are targeting filing a patent application, you can always, at least you can read research papers. What are the latest developments? Is my invention falling in this ambit, or no, my invention is still different from whatever the latest developments are? So suppose at any stage you think that whatever your invention is or whatever you're working on is getting published or something, then make a point to enhance your invention, add some extra features in it, or make something unique about it. And always, you can always consult a patent agent. Sometimes it happens that we have an invention but we don't know exactly whether it's already published or not. Are there any similar patents? Or I have an invention but I don't know exactly what is the uh, most unique aspect of this invention. So once you work with patent agents, then they help you throughout the entire process, right from searching to the drafting. So drafting is also a very key point. Your invention might be new, but sometimes what happens is the drafting is not done in a proper way. And so the unique features are not brought out in the claims. In that case, the invention loses its charm. So as much as searching is important, equally important is the proper drafting of the patent specification. So if your patent specification is drafted smartly, then it's very likely that your patent will get granted.
Thank you, Ashwini madam. One more question from my side, and
Yes, ma'am.
later on, students, you all can also ask her a few questions, I suppose. Uh, I just wanted to know, like, how many, as your key domain area is patent, how many students come to you, or how many students are applying for patents every year? Do we have that type of statistics or some data?
Statistics as such, I don't
Or
have,
like
but
whatever is your experience in that
yeah,
domain,
yes, ma'am. So
this
many
may
times it
ignite our
happens.
students.
Yeah,
Yeah.
it happens that irrespective, like there's no age constraint or anything for being an inventor. So you can many times we have filed patent application for students or for research groups. Uh, we have filed, and suppose like even if you I personally think that even if you're not sure about your invention, at least you should give it a shot. So because one, there's always room for improvement. Once you get your invention, you can always go back and forth, see what is there in the art, then improve your invention, or then write it in a better way. And then for each and every step of prosecution, you can give your inputs. Like most of the technical data needs to be included in the complete specification. After that, you cannot amend your complete specification as such, but at the time of first examination report also you can amend your claims. So it's always a good idea, if you have an invention, you can try for a patent, because the fees for individual is very less. Like the government fees is 1600 right now. So these fees keep changing from time to time, but right now the online fees for filing a patent specification is 1600. So anyone can, means many students come, and sometimes they are pursuing their PhD, or some are undergraduates, some are postgraduates. All kind of people approach us to file for patent application.
Any more
Abra madam?
questions? Yes. Before vote of thanks, May I request all the participants to please switch on your camera for one group photograph?
Madam, will you
Yes,
stop
ma'am.
sharing your
Yes,
screen?
yes,
That will help
yes,
us.
yes, ma'am.
All the participants, please switch on your camera.
Others?
Okay, thank you. So coming to the end of session 1, it is my privilege to propose a vote of thanks of this session. I, Shilpa Kabra, with Professor Sushma Agrawal on behalf of Institute Innovation Council, Government College of Engineering, Aurangabad, extend a very hearty vote of thanks to our honorable speaker, Ambika Pawar ma'am, who enlightened us with her knowledge and took out valuable time of her busy schedule. I must mention our deep sense of appreciation for you, ma'am, and I am really sure that today's session will help all the participants in enriching their IPR related knowledge. Once again, thank you, Ambika ma'am.
Thank you.
Now I request Agrawal ma'am to start the second session.
Gulwar sir will be joining in 5 minutes. So in the meantime, yeah, we can have a 5 minutes break.
Yeah.
And just, I'll have a word with Ashwini madam. How was your experience? Like, I don't know, our students did not decide to, they don't ask much nowadays.
And no, ma'am, no issues with that. Actually, a patent topic itself is a bit difficult to and time taking to understand. So I don't blame the students as such. It took even me a lot of time to understand all the aspects that I know today. So I had basically started from patent searching. So
Yeah.
yeah. So first I was into patent searching, and then I gave my patent agent examination, and now I'm full-fledged working for like almost 2.5 years in specifically in patent drafting and prosecution. Before that,
Okay.
for almost 5 years, I was doing patent searching.
Acha, acha. And it so happens, madam, I feel like last 2, 3 years or 5 years, we all
Yeah.
of us are talking about patents. The students are hearing about them. 10
Mhm.
years down the line, this was not the scenario, I suppose.
Actually,
Like,
ma'am,
unless
like
you do
many
research, you will
features,
not.
yeah, like a lot of developments have been happening in our patent law as well. Like now our law is mostly it's at par with whatever laws are outside India. So like even our patent act has been amended from time to time. So right now whatever the provisions of the law are very good, and every year patent office tries to incentivize people to file for patents, like uh, especially if anyone is from startup, they have option for expedited examination, like that allows for fast prosecution of patents. So it has also happened for few people, like within a year the patent gets granted. So earlier it was like it used to take 4 years or around, but now that has changed. Patent office also has hastened up, and they have fastened their process also. And also like more people are realizing the importance of patents, and now with online filing and all,
Yeah, that's what
it's
I was
become
feeling.
easy.
Easy, things have become easy. Paperwork and all, everything online. People also can put things faster. They realize their queries also
Mhm.
faster, I suppose.
Even
Queries.
accessibility is a big thing, ma'am. Like my education I had done in Raipur, Chhattisgarh. So till then I had like I had textbook knowledge of patents. So once I came to Pune and I started working in the field of IP, and then I realized how all these things work and how everything is connected. Like patent is not a standalone field. It is it
Yeah,
has risen
we
from
had
the
organized.
importance from whatever research you're doing. So because there is research and developments, and that's why IP exists to protect that research and development.
That's true.
Yeah.
Last year also, I think our institute had organized 1 day workshop on IPR from by Rajiv Gandhi National Institute of
Yeah.
IPRs
Nagpur.
is there in Nagpur. Yeah,
Yeah.
those people had come and they also said like nowadays the patents are being awarded much faster than earlier cases.
Yeah, that's the main thing, ma'am. Because as a overall, if we see patent costs tend to be a bit higher, but because that concession in fees and the faster prosecution, still people are willing to consider going for a patent. So like earlier people used to like target for research publications, but more and more people are coming to know about patents. Then many people are preferring patent publications and then going for research publications, because once your research is published, then it becomes known, and the patent loses its novelty. So this is one thing I would like to tell, ma'am. So if anyone is targeting for patent, make sure that you file a patent application and then go for research publication.
We have many faculties also in the session. I
Yes,
hope
ma'am.
if they have some doubts they can ask, or if they want to discuss a case, that can also be done over here. Regular
Sure,
sir
ma'am.
will be joining in few minutes.
Sir has joined. Welcome, sir. Good afternoon. Sir, I think you are on mute.
Good afternoon, madam.
Good afternoon, sir.
So, madam, lecture is over.
Yes, sir.
Okay.
Agrawal ma'am, shall we start?
Yes,
Regular, sir?
shall we start? We'll start with the second session in that case.
Yes, yes.
Madam?
Thank you, Ashwini ma'am.
Yes, ma'am.
You are going to be there. Yes. Good afternoon, sir.
Good afternoon, madam.
So, welcome, sir. Dr. D.G. Regular, sir. He is a professor in Civil Engineering Department of our institute, and he is also handling another portfolio, which is Dean Academics. He has worked as Dean R&D also earlier on. He had completed his PhD degree from National Institute of Technology, NIT Warangal in 2006. His research areas are water resource systems modeling, multi-objective optimization for river basin management, fuzzy logic applications in water resource engineering, and applications of soft computing in once again in water resources engineering. He is recognized guide for Bammo University, PhD guide for Bammo University. 5 research scholars have been awarded PhD and 7 are working under him. He has guided 52 ME students for their dissertation work. The total number of journal conference publications to his credit is 123. He has completed 3 research consultancy projects. He has 1 patent awarded to him, 2 design patents, 2 copyrights, CAS app, a mobile app, and a Bhumi Tantra software. There are 4 trademarks to his credit. He has filed one patent, which is published in the Patent Journal. He is working as an associate editor of ISH Journal of Hydraulics Engineering, Taylor and Francis. He is a representative of the Institute of Repute under National Knowledge Network, NKN. He has worked as a coordinating faculty of the Institute for MHRD's National Innovation and Startup Policy for about 1 year. He is an executive council member of Indian Society for Hydraulics Pune for the time period 2020 to 2022. He is an executive council member of Indian Water Resource Society, Roorkee, from 18 to 22. He is a life member of ISH, IWRS, IEI, ISTE, and IAH. He has also worked as a member of the Board of Studies in Civil Engineering at the University of Pune. Presently, BOS Civil Engineering member of University of Mumbai and MGM University, Aurangabad. He is a reviewer of 15 international journals. He has organized 15 national conferences, workshops, and 16 national level AICT, IST TechCube short-term training programs. He has edited 4 books, 6 book chapters to his credit. He has delivered around 75 keynote addresses, a huge number, sir, expert lectures, and participated in 46 short-term training programs. He also has worked as a session chair in national international conferences in IIT, BITS, Hyderabad, state colleges. He has visited Chengdu, I don't know if I pronounced it correct or not, China in 2013 and Delft, The Hague, Netherlands in 2015 for presenting his research work at IHR World Congress. So this is the biodata of Regular sir, and I request now Regular sir to start his session on intellectual property right. Welcome, sir.
Yeah, thank you very much, Agrawal madam, for warm welcome and reading my biodata. Already our institute association, which is with Mahurkar, and a representative, Ashwini madam, she has taken lecture, and the awareness, of course, she might have given, because due to some other work I could not attend it. Basically, my job is to whatever IPR I have received, I have granted. So to give the detailed idea about it. So that is what my job is. And whatever IPR like I have received, that is through Mahurkar only. Previously it was Krishna and Saurashtriya, and now it is AM Legal Associates. So briefly I will go through some definitions and all, and then one by one, like the patent which I have received, the copyright, trademark, and design, and how the specifications that time I have prepared, the claims I have written. So that kind of detailing I will show you. So this is how the patent website madam might have shown you. And in fact, I appeal to all students. So if you visit this website, you can get a lot of information about the patents, design, trademark, and the geographical indicators. So the all procedure, the patent filing procedure and everything, it is available on this website. So what is need? It is to go through this website ipindia.gov.in. So a preliminary information, definitely you will get it. And like whatever, I mean, you are working for some incubation or maybe startup or something, you may think of filing an IPR. Okay. So briefly, just we go through the invention and innovation. Like innovation, it is a new idea, more effective device or process. Of course, these all definitions also you will get in the on that patent website also. So innovation can be viewed as application of better solutions that meet the new requirements in articulated needs or existing market needs. So this is accomplished through more effective product, process, services, technologies or ideas that are readily available to the market, governments and society. So this is how we look through the innovation. It can be defined as something original and more effective, and as a consequence, new, that breaks into. So this is more important, the breaks into the market or society. The other is invention. It is a unique, novel device or method, composition or process. The invention process is a process within an overall engineering and product development. So it may be an improvement upon a machine or product or a new process for creating an object or a result. Such works are novel and not obvious. So madam might have in depth discussed about the not obvious and novel to the others who are skilled in the same field. So this is very important. So whenever you develop any idea or based on that some product, so whether it is novel or not, so the best thing is to judge is that should not be obvious to the others skilled in the same field. That means you have to compare with the skilled persons in the same field, and then you can think of going for some uh, uh, patenting part of it. These are few examples just I had with me for presentations, like Volta with the first electrical battery. On internet sources, you will get so many information on patents, who is recognized as one of the most influential inventors of all time. Thomas Edison, then Steve Jobs. And what is desirable, basically innovation, when you think of the three circles, when we think like what is desirable to the users and what is possible with technology and what is viable in the marketplace. So this is how we have to think whenever we we want to go with some innovation part or some patenting process. So what is desirable, then what is possible, and what is viable in the marketplace. Then this innovation journey in the high-tech, high-speed businesses, like idea generation is of course the first one. Idea exploration, that is second. Then some overlapping between the prototype and idea exploration. We have to select it. Then implementation part, you develop it, prototype and develop. Then whether to go ahead or not, you have to decide. That is what the go or no go condition. Then prepare for the market, launch it, and the support. If not possible, some learning will be there. Again, this can be continued with idea modification, exploration, prototype, then developing, preparing, and launch and support. So this is how the innovation journey we have to think of. The patent, of course, already you know it, like statutory right for an invention granted to the patentee by the government, and it is granted in exchange of full disclosure of his invention. So you have to disclose your invention. And the patent counselors, of course, they have their own procedure to invention disclosure form and other things. They have it. You have to fill that form. For excluding others from making, using, selling, importing the patented product or process, for producing that product for those purposes without his consent. So these are like the, legal document and legal statements you'll find on patent office website. So it's a territorial right, because it cannot be applicable everywhere. So every country, they have their own procedures. It is for a limited period of time, like patent for 20 years and all. So that protection is territorial, and it is effective only within territory of India. However, filing an application in India enables the applicant to file a corresponding application for same invention in convention countries. So this information is given on website within or before expiry of 12 months from the filing date in India. So a separate patent should be obtained in each country where the applicant requires protection of his invention in those countries. So there is no patent valid worldwide, and it is possible to file an international application in India as patent cooperation treaty application in the patent offices located at Kolkata, Chennai, Mumbai, and Delhi. Okay, so these are all receiving offices, and you will get information on this ipindia.go.in website. What can be patented? An invention regarding relating either to a product or process that is new, involving inventive step, and capable of industrial application. So this is first, that is novelty. Second is it should have some steps, and third, that is the capable of industrial application. So any one of these, if it is not there, then of course it cannot be patented. However, it must not fall into the categories of inventions that are non-patentable. So under the section 3 and 4 of the Act, few things are listed which are non-patentable. You have to read that list. Okay. So a patent application can be filed either by a true and first inventor or his assignee, either alone or jointly with any other person. So this is who can file a patent. And however, the legal representative of any deceased person can also make an application for patent. So the procedure is like it can be filed with Indian Patent Office, either with complete specification or with provisional specification also. Of course, along with fees, and that is prescribed in Schedule 1. So provisional specification or provisional application, that is also possible. So if you want to protect your ideas, you can go for provisional specification. Madam was talking about like first patent and then publication. But if ideas are not that much clear, you can go for the provisional specifications. In case the application is filed with provisional specification, then one has to file complete specification within 12 months from the date of filing of the application. So there is no extension of time to file complete specification after expiry of this 12 months. Criteria, of course, just now we have seen the three criteria. One is novelty, second is inventive steps, and third is industrial applications. Okay. Then patent filing should be before publication. The application of patent should be filed before the publication of invention. Until then, it should not be disclosed or published. This is very important in patent. So that is what you have to hide from others. Whatever innovation or invention it is being going on, it is always better to hide. Don't discuss much more in meetings and in other things, because I have seen one of the meeting that everyone was disclosing their ideas, their product in the meeting. So that is not desirable actually. So you have to disclose with only the patent counselors. So that care everyone should take it. So please do not disclose, even if your friends are there, your faculties are there. It is always better not to disclose, not to give information, not to write and put it on notice board, even notice board also, so that anybody can read it. So don't put it these informations everywhere. Okay. So disclosure of invention by publication before filing patent application may be detrimental to novelty of the invention, as it may no longer be considered as novel due to such publication. So, however, under certain conditions, there is a grace period of 12 months for filing application even after publication. A patent application for the invention which has been either published or publicly displayed cannot be filed. The Patent Act provides a grace period of 12 months for filing the patent application from the date of publication in a journal or its public display in a exhibition organized by government or disclosure before any learned society or published by applicant. The specification, if you see the title, prior art, drawbacks in the prior art search, that means in our academics how we write the literature review. So there also the literature review is there. So the prior art search, it is to be carried out. What are the drawbacks in the prior art search? That is to be mentioned, like we write the research gap. The solution provided by the inventor to obviate the drawbacks of the prior art, a concise but sufficient description of invention and its usefulness. This is very important. So you should be able to defend the invention and its usefulness. And the drawings, if any, and details of the best methods of it working. And the complete specification must contain at least one claim for which you want the protection, or the statement of claims defining the scope of the invention for which the protection is sought for. So these are specifications. One of the specification for the patent which is granted to me that I will show you. Provisional specification. The Indian patent law follows the first to file system. Provisional specification describes the nature of the invention to have the priority date of filing of the application, in which the inventive idea has been disclosed. It must be followed by a complete specification, of course, within 12 months. And if the complete specification is not filed within the prescribed period, the application, it is treated as deemed to have been abandoned. Generally, an application filed with provisional specification is known as provisional application, which is useful in establishing a priority date for your invention. So filing of a provisional application is useful as it gives sufficient time to the applicant to assess and evaluate the market potential of his invention before filing the complete specification. And however, it is not necessary to file an application with provisional specification, and one can file application directly with the complete specification. So publication of patent in patent journal. So every application for patent, it is published after 18 months from date of its filing, or the priority date, whichever is earlier. However, following applications are not published, like secrecy direction is imposed, and some clauses are there that is to be read clearly. There is a provision of early publication. You need not to wait for 18 months. So the applicant can make a request for early publication in Form 9 along with public prescribed fee. So after receiving such request, the patent office publishes such application within a period of 1 month. So you can save at least 1.5 years if you go for this early publication. Provided the invention content thereon does not relate to atomic energy or defense purpose. The request for examination can be filed within a period of 48 months from the date of priority of or date of filing, whichever is earlier. So for more details, of course, some sections are there you have to refer. So this is what it is, more of the legal. So mostly the advocates, I mean the counselors, they play an important role in this. The language, what is required, and all the clauses and the act. One has to go through this. So as we are very busy in our own, inventions and technical things. So the basically while filing the patent, the language what it is required, a legal language it is required. It is difficult to write us. Like even because when I have written that complete specification. So maybe I could write that in one paragraph. But when the final specification is prepared, so that one paragraph has become at least 2-3 pages. So that clarity is essential for patent specification. So after examination, the patent office issues an examination report, which is called as the first examination report. So applicant has to defend for this. He has to comply with requirements. And again, the time given is 12 months from the date of FER. So if the application is found to be in order for grant, the patent is granted. So provided there is no pre-grant opposition is filed for or pending, because somebody else can file a pre-grant opposition. Okay. So parts, of course, the claims are very much important. So what the protection you need, the description and drawings. So to teach, address to persons skilled in the art, disclose the best mode machine as contemplated by the inventor. Requirements must be new. Of course, this is new, non-obvious and industrial application already we have defined. What cannot be patented, of course, Madam might have discussed much in detail. Something I have with me like medical treatment cannot be patented. Scientific principles or abstract theorems cannot be patented. Software cannot be patented, but copyright can be taken. Business method, professional methods, and all. So these all cannot be patented. But out of this software can be, copyrighted. So this software is not patentable as an article. Software is patentable as a method, provided that the method involves more than just a calculation. So may be considered as a mere mathematical algorithm. The hardware which relies on software, that is patentable. So these things we should understand. There are so many agencies, but these nodal agencies for IPR facilitation in India, this is a TIFAC, IP India, IP India services.gov.in. Then IP India Online, this is for filing patent. These are all different, like Technology Information Forecasting Assessment Council. Then Controller Journal of Patent Design and Trademark website is there. Indian Patent Advanced Search System is there in past. This website is given for checking the status or patent application, online filing of patents. Then World Intellectual Property Organization site is also there. So just I have searched and I got something like invention. So think of an invention that you use regularly that would impact your life greatly if you had to live without it. The very first is, of course, the telephone or now mobiles, bulb, vehicle, even this U pin, safety pin. So without this, we cannot imagine now, but they are inventions. Innovative products now with little bit impressive designs. This is from civil engineering. This is mobile. Even this zip. These are all innovative products. So invention, like a new man-made device, process, innovation, a better way of doing things. So this is a innovation. This is a old one. Okay. Some evolution process is there in every product, like telephones, there is innovation. Computers, there is innovation. Trademarks that give an individual or corporation a right to identify a product. Right to identify a product with a graphic symbol that customers can readily recognize for the quality and service. Basically, this is for quality and service they have earned. Okay. So trademark has no time limit. So Nike, Mountain Dew, so many trademarks you can just think of. Adidas, these are all trademarks. If these trademarks are there, we pay a lot of money to buy that product. Okay. Copyright provides the creators of written materials the right to a profit from the sale of their works for a definite period of time. So the symbol to be used for copyright, it is this C encircled, related to written material, graphic material, music, etc. A copyrighted, I mean, always we say it's a copyrighted music, copyrighted graphic material, written material. Maybe a book, it is copyrighted. Music, copyrighted. Graphic material, it is copyrighted. Even our website design, that is also, the copyrights are with someone, XYZ. Okay. Something to understand, like ideas without risk, they are useless. On the other side, while risk without ideas, they are stupid. So that means ideas should be there and some risk, that is always helpful. So now I will go with the what our product is. So this is how one of the like bearing converting instrument for surveying. So in civil engineering, so like those who have gone through survey, that is the basics of civil engineering, or basics of civil engineering if you are not from civil engineering background. So you have dumpy level, then compass you might have studied, prismatic compass. So that prismatic compass that reads the bearing. So bearing, it is nothing but it is a angle made from north, that is magnetic north, to a survey line. This is what is simple. If this is a north, and if this is a survey line AB, so this is north. So this angle is called as bearing. This is a simple concept. Okay. Now this bearing, it is measured in two ways. One is the whole circle bearing, and the other is the reduced bearing, WCB and RB. So WCB means always with respect to north, what is its angle? Therefore, it will read up to 360 degree. Whereas the reduced bearing, that can be read within the quadrants. So first quadrant, second quadrant, third quadrant, and fourth quadrant. So north to east, south to east, south to west, and north to west. That means angle always remain within 90 degrees. Okay, that is called as the reduced bearing. So either whole circle bearing or reduced bearing. Okay, so if you want to convert from whole circle bearing to reduced bearing, there is a calculation, because that 360 degree, you have to convert that into the quadrants. Okay, so the concept is very simple. So when you want to convert this from 0 to 90 degree, if your whole circle bearing is, then reduced bearing is equal to the whole circle bearing. There is no need of any calculation. But quadrant is northeast. If your whole circle bearing is between 90 to 180, now in this 90 to 180 here, in that case, it will be 180 minus whole circle bearing. So whatever your angle is, suppose this is the WCB. So WCB is more than 90, less than 180, say 100. So 180 minus 100. When it is 180 minus 100 means somewhere this angle you will get it, theta. So that means it is southeast, from south towards east. So this is a southeast quadrant, 180 minus WCB. Similarly, in third quadrant, similarly in fourth quadrant, you have these quadrants and these calculations. So you have to do these calculations by calculator. You have to do this calculation by calculator. And if you want to measure it, then you need this WCB. That means you need a prismatic compass. And this reduced bearing, one more compass is there. It is a surveyor's compass. So surveyor's compass measure this reduced bearing. Prismatic compass measures whole circle bearing. Or you use surveyor's compass, then convert whole circle bearing, or you use prismatic compass and then convert into reduced bearing with the help of this type of table. That means the calculations are there. If you want to measure actual observations, then you should have two different equipments. You should have two different equipments and 2 times observations, because one time prismatic compass will give you WCB. Other time you have to remove that prismatic compass and you have to set up a surveyor's compass and then you take the reading. So a lot of time involvement is there. Okay, and as well as the money involvement, because two different equipments are required. More time for observations or more time for calculations. Okay, so these all problems are there in prior art. Okay, so that is what the two parts we did this into the two parts. One part is this conversion. Okay, so how to convert this? One is by calculation, the other is simply this two disc we have prepared, and these angles are marked such that these angles, they are marked such that one above the other, two different discs are there. So bottom, if it is RB, reduced bearing, and if this is the index, okay, so this index is corresponding to suppose 80 degree. Okay, so the another index is here. This will read the whole circle bearing. What you have to do, simply you move this index. If you take it to here, suppose 60 degree, then corresponding index on the upper disk will give you the whole circle bearing. So reduced bearing and whole circle bearing you can get simultaneously. No calculator is required, no calculations are required, nothing is required. Simply you have to revolve that index. Simply you have to revolve the index corresponding to either WCB or RB. Suppose you are having prismatic compass, then focus here and corresponding to that you will get the reading on the reduced bearing. So this reduced bearing you will get it. Or if you have surveyor's compass, then focus on this RB somewhere here and corresponding WCB you will get it. So this is how our first idea it came to the mind, and basically the idea was for a compass only, that is a combined compass. That was an idea. So thereafter, while discussing with Mahurkar and all, we have divided that into two parts and two different applications we have filed for both the application. Like one is for this bearing converting instrument and other is for the combo compass. For both, we have received the design registration or design patent, and both we have applied as a patent application. Out of that, the combo compass, the patent is granted, and this bearing converting instrument for surveying, this particular patent application first examination report is over. We have submitted the examination report. Now we are waiting for the, whether the grant or not granted, whatever it is, that decision it is pending. So we hope in due course of time it will come, maybe granted or may not be. We don't know what will happen regarding that. Okay. So this is how a basic concept I have shown you. So yeah, so this is how the application number in 2014 it is filed. So still we have not get any result from this, but examination is over. Okay. So this is the first one. This is the design for this. The design is already granted. And this is the second, that is combo compass bearing measuring instrument for surveying. This is also filed in 14, published in 15, and thereafter in December 21, 2nd December 21, the patent is granted. Okay. Now here, if you see, the two discs are there. This is the bottom one and this is the top one. Okay. So a normal prismatic compass, when we see, there is only one disc. So what is the novelty here? So the preparation of this circle, so that suppose this needle, it is a magnetic needle. Suppose it reads here a reduced bearing. Then exactly above that, it reads whole circle bearing. That means when I look through this object when, then I will get whatever observations are there. So the reduced bearing and whole circle bearing simultaneously. So even there is no need of conversion and all. So this one equipment will consist of two different equipments. So previously, two equipments were required. Now these two equipments are not required. Only one equipment is sufficient. One instrument is sufficient. And the overall features also, they are similar to prismatic compass. So anyone can use it. Only what he has to do, corresponding to this crosshair, whatever he looks at the bottom ring, immediately he should look at the top ring. So these readings are, one is at the bottom circle, that is a what we say reduced bearing, and the top circle, it is the whole circle bearing. So this is the simplest way. So it is not much more complicated and all. It is simple. But the application wise, if you see, the application is much more. So it saves a lot of time. It saves a lot of time. All the concept in the previous slide, whatever I have shown, the similar kind of concept is there. But now here only actual observations. Here actual observations are there. Okay. So this is how the prismatic, the combo compass, which measures the whole circle bearing as well as reduced bearing. Okay. So design already we got long back, maybe in the year of I think 15. Yeah, in 15 we got this design, and then we have applied for this patent in 2015, and in December 21, yeah, 2nd December 21, we got this patent. So patent is granted. Combo compass instrument for survey. Okay. So this is how about this combo compass for surveying patent, and its specifications I wanted to show you. These are the specifications. So basically specifications will include like field of invention, then background. Look here, in the slide, I mean PPT, how much I could write is this. At the most, when I have given the write-up, that was not more than 1 page. Okay. So now when you look to this specification, background of invention, so these things require some help from the counselor. Then summary of invention. What is the summary? Then brief description of drawings, detailed description of invention. So you have to write much in detail. This total 13-page document is there. In depth, each and everything, it is to be specified. One of the example that how it works and what are your claims also. So at the end, we write the claims, and these are very important. So simply to read it, one or two I will read so that you can understand how minutely it is to be written. So a combo compass instrument comprising a whole circle bearing scale ring and a reduced bearing scale ring concentrically located in a predefined position within a case, thereby having a magnetic needle and a pointer pivotally positioned at the center thereof, the pointer connecting to the magnetic needle at a predefined angle towards north side thereof, the magnetic needle having a counterweight connected thereto, at a south side thereof, the counterweight preventing a dip of the magnetic needle. So basically here is what, of course, we have a lot of ideas, but in depth, rarely, we could write it. And such clarity of each and every point that is essential when you go for writing the complete specification. So similarly, the combo compass instrument as claimed in claim 1, wherein the predefined angle between the magnetic needle and the pointer is so and so. The combo compass instrument as claimed, because this basically this 1830, that is, you don't find anywhere, because that is what our invention is. Again, more kind of things are there where we have specified, because if only that angle is there, then only it works. The combo compass instrument as claimed in claim 1, wherein the counterweight is made of non-magnetic material. So we never think of this writing such statements that we know it is a non-magnetic metal, but we think it is very simple. Why to write? So these things happens when you go for writing the claims and the complete specification. The counterweight is made of non-magnetic layers that are positioned on either side of the needle. So like this, 9, 10 claims are there. And all these 10 claims, it is protected. All the 10 claims, it is protected. So this is what I wanted to show you regarding the specifications. And this is a procedure. The filing procedure. Some abstract is also required. So the total number of claims 9 to 10. This is how a patent application publication So those already filed, they might be knowing it is there in patent journal. So there they write the patent application number, date of filing, date of publication. This is a 16 date of publication because I have not gone for any early publication. So the total number of claims, they are 10. Just now what I have shown you in complete specification. And the abstract they require to publish in this patent journal. So in the complete specification at the end, we have I have written this abstract. So this abstract they print into the journal. Okay, and in this journal it will remain for till the examination. It remains. Anybody can file a opposition of this. If someone is very sure that this is a copied material, then they can object. Okay, so this is about the patent journal. Similarly, designs are also being shown in being published in patent journal. So this is a design part. So for the first one, that is the bearing converting instrument, and whatever you are published here. Okay. This converting instrument for surveying, and it is in the official journal of the patent, but it is for designs. Okay. Then, yeah, this already. Yeah, this is the second publication. Now this patent, yet it is not granted, but it is published in patent journal as well as FER is over. First examination report is over. We have submitted the queries, and here we have this 9 claims, right? Then yeah, trademarks also 4 trademarks are there. Trademark also one of the IPR, and this trademark it is granted in 17, and that is for this CAS app. So I've proposed some name for a mobile app that is a CAS app, and that CAS app I have protected like this: K capital A Z A double P, A capital double P, and similarly in 2 different classes I have applied. This is another one, Bhumi Tantra. Then this class is different, Bhumi Tantra, and this CAS app class again it is different. So this is some class 9, and this is class 42. Some 2 different classes are there. So these, of course, I was not knowing, but due to Mahurkar, this AM Legal Associates, I could know even these classes are also there, and we can get the certificate of registration of trademark. So we were here regarding this patent. Then one more which I have is CAS app, that is the a mobile application. Okay, so it is a software work, CAS app. This is a mobile application for labeling. Again, for the survey itself, I did it, and basically in survey, if you remember, those who have studied these basics of civil engineering, you have a labeling work. Okay, so in the labeling work, you have the 2 different methods. One is the height of instrument, and other is rise and fall method. So this is corresponding to HI, that is height of instrument method for labeling. Okay, so you can this app, mobile app, you can write name of the work, then name of surveyor, that is who is doing the survey and what is the date. So those who are from the computer background, they may understand very easily. Then what we need, so after this, when you write the name of the work and survey, the next, when you enter next, it will go to this enter values. Then it requires the reduce level. So then chainage is also required. So whether your chainage is left chainage or chainage is right chainage. Okay. And what is the last entry? What is the last entry? Okay. So basically the RL means it is the benchmark RL. And then what you have to enter, it is the backside here. It may be between 0 to 4 meter. That is a range for this staff, leveling staff. Okay, so that you can write it here. And then it has a calculation of RL of benchmark plus backside is height of instrument. So it will come here. And then HI minus IS, that is intersite, or minus foresight. That will give you the reduced level for the next. So this is how a procedure is. So when you go ahead, this is what. Now you have this IS. So IS means, HI. HI means it is RL of benchmark, that is 500, and BS is 1.255. Look here, 1.255 and 500. So it is 500, 1.255. So it is 500, 1.255. Now IS actual dumpy level reading is this. So 501.255 minus this. That will be the RL. Okay. So 501.255 minus 3.525, that is RL. Now it is printing in the background. At the end, as a report, it will come. Minus FS, that means I just make it end. Okay. So next is this one. Last entry given. And it will give you, when you end this, it will give you a PDF report. So PDF report is this. So whatever entries I made, 1.255, then 1.655, at the end 1.635. This is benchmark was 500, then HI is 500 and 1.255. Like this, these are the reduced levels. That means this column. Okay, and it has certain check also. It is called as a arithmetic check. That is summation of backside minus summation of foresight is equal to the last RL minus first RL. This is the check. And this check should always be correct. So minus 0.38 and minus 0.38, it is okay. What are different legends, whatever the short forms I have used, it is written here. Okay. So this PDF report is generated, and this we have submitted for copyright. And this copyright, it is granted. In a similar way, now this operates on mobile. Okay, mobile app. The same thing on desktop or laptop, a software kind of thing. So the same software, but the name we have given Bhumi Tantra. And this is how a window for this Bhumi Tantra software, wherein this all backside, foresight, intersight, everything it is being written here, where we can input the backside, reduced level, intersight, foresight. Okay, then arithmetic check is also there. Whether this check is okay or not, that also displays. And this report, it is displayed here. The same report, because same example I have taken on at both the places. And it is saved also. Okay. So this is how the second one, Bhumi Tantra. This is a survey report for this Bhumi Tantra, and along with the arithmetic check. For this, of course, the copyright it is taken. So this is how combined IPR I have taken, and recently just it is given in the newspaper also. So these are all regarding whatever I did. And yes. Okay. So these are all from my side. If any discussion is needed. Yes, Agrawal madam.
Does anybody have any question? Faiza, boys, girls, anybody? A feedback form has been uploaded. Please, everybody try to complete it.
I think there are no questions, madam.
Thinking anybody asking any question? Any question from our faculty, students? One or two questions must be there. Sir has taken a very good lecture where he has tried to highlight all his works.
They have understood all.
IPRs, whatever IPRs he has applied, how he has gone through the procedures. Yeah, they must have, but in spite of that, I feel they can ask you few questions.
Only from my side, I can tell one thing, that whenever some ideas are there, be within your group only. Don't disclose.
Yeah.
Even in meetings also. In meetings, you can take a separate meeting for separate group.
It should not be public.
Yeah, not combined, not with the outside experts. Because sometime if it comes in some public domain, it may be a notice board also. Notice board is also a public domain as per Patent Act.
Act, yeah.
Yeah. Newspaper, notice board, or maybe a magazine or something like this. So till we apply, it should not be disclosed. And that is why people go for the, provisional application. Once they have idea, they go for provisional application, and then of course they are free.
So no questions from your student side. I hope everybody has filled the feedback form. Please do that. We need to put all this data on Institute Innovation Council. We have to upload it to IIC website portal. All the information we have to, even sir, we have to upload these lectures on YouTube and send a link to IIC.
Okay.
So all these things are there involved. They need screenshots, recording, uploading of lectures, and even whatever banner which we prepared, that has to be like uploaded on social medias, Twitter, Facebooks, and they need link of those like publicity material also. So all these things are required whenever we conduct, and they actually want minimum 20 students, 20 people to attend a session. Yeah. So that is a mandatory requirement from them. Anyway, we'll come to the end of this session then in that case.
Yes.
Yes. So I myself will propose the vote of thanks on behalf of our institution, Government College of Engineering, Aurangabad, and Institute Innovation Council. I would like to thank Dr. D.G. Regular sir and Ashwini Pawar madam from AM Legal Associates for giving us a very insightful, thoughtful, and what I should say, a lecture which will intrigue us to go into how to apply for IPRs. I am very much thankful to Ashwini Pawar madam who took out time out of her busy schedule and gave us a session on patent. Her forte is patent. She highlighted the same. Regular sir, he highlighted whatever work which he had done or applied for IPRs. The two things for patent which he has applied. One was bearing converting instrument for surveying, and the second one was combo compass. It is also a bearing instrument for surveying. So these two patents he has shown in detail, like how do they operate, how it has to be applied for, or what type of material he has written down. So all these things here. So I am very much thankful to all the faculties, students who have taken time to attend this particular session. Basically, it's a Sunday, and 31st July is the last date from IIC on which we can conduct sessions. And from tomorrow to 10th of August, they have given us a timeline during which we have to upload all the documents related to it on their portal, and accordingly they will sanction our grants. I am very much thankful to Ratnaparki madam for initiating these impact lecture sessions, and Bhalchandra madam, our principal, for giving permission to conduct these sessions. Thank you everyone, and with the permission of everyone, I will like to close the session. Thank you everyone. Sir, one thing, we can turn on our cameras, take one screenshot.
Okay.
Faiza, please do that.
Yes, ma'am.
Everybody else, Sanket, Moniraj, Amruta, Utkarsh, can you please turn on your cameras? Faiza, you yourself? Okay. Thank you, sir. Acha, Utkarsh, yeah, people are coming back.
But in incubation, how many students are there?
So right now, 9 students are working proactively.
9.
One of them startup is almost ready to be launched.
Okay,
And
okay.
for that only we are we are planning to doing it in the next month, coming month itself. Only they have started launched even beta testing of their website that is related to some software, and website they have gone ahead with it. I think Ashit was there, now he is not there. So that we are thinking of. Beta testing has been launched. Now they have few problems, like they need one books. Right now they are doing only fiction and non-fiction books. Later on they will go to textual books. So that copyright also they are interested in filing for the same. Hope so they do it fast. So the only thing is that developing a website by 1 or 2 students is not an easy job. Like they did it on their own.
Okay.
And they are more interested in I think they are more interested in how to develop a website. Connect it with the iWallet and all they are doing. I hope it works. Okay, sir. Thank you then.
Okay. Thank you very much. Yeah.
Yes.